We have here a landmark decision in American history as it relates to presidential power that will define the limits of that power for generations to come. The divided court now deciding here that the former president does enjoy some immunity. There is a dispute about how much and to what extent. But what we do know is that this case is now going to go back to the lower court for further delineation about what is immune, what is official, and what is not. The Chief Justice here accusing his liberal colleagues of striking a chilling tone that's disproportionate to what the court actually does. So you see a dispute here with the liberals saying that they've gone much further than the conservatives think that they actually have gone here. But they are saying that immunity extends to official discussions between the president and his attorney general. But they're going to put it back in the hands of the lower court, Judge Chutkan, the trial court, to determine what extent Trump's remaining alleged conduct is entitled to immunity. Remember, this is the case where he's been accused of trying to overturn the last election through lies and through fraud. He has resisted that and obviously denied any wrongdoing and has said that everything he did was completely within presidential powers, and that if you don't offer immunity to presidents, then they'll just essentially be handicapped into not being able to do their job, right? That there will just be a series of recriminations with the next administration prosecuting the former one. Again, the conservative majority here saying the president does enjoy some immunity, but there is no immunity when it involves unofficial acts. So say the president committed a crime, say he killed his wife or he robbed a bank while he was in office. Yeah. That's not immune. But anything having to do with things that he was doing as president, as part of those official duties, the conservative majority thinks that is immune. And therefore, it now has to go back to the lower court for more process, which means more delays, which really is going to have a big effect on timing of this case to be able to get completed and finished before the November election.
It sounds as if there's little to no chance that this case sees a courtroom before the November election.
I need to go through it. It's a lengthy opinion. I want to see what they say, if anything, about timing, because as of right now, I don't see them acting with any alacrity. I don't see the urgency here quite yet, but we're going to work our way through and see if they address that in some respect. And I'm sure the liberal branch of this, I'm sure, has something to say about timing.
Danny Savalas, I know you've also been sifting through the decision as well. What do you make of what we heard from the High Court?
At first blush, this is an opinion that you might read and think, oh, there is absolute immunity, so Trump is off the hook. But it's much more nuanced than that. In fact, the court takes a position that was actually conceded by the government on absolute immunity. And it essentially holds that there is a kind of absolute immunity, but only for core presidential functions. And Attorney Dreeben for the government essentially conceded that at oral argument. He didn't call it immunity, he called it something else, an Article 2 defense. But the justices said, look, whether you call it a defense or immunity, it's something. So the court does hold today that there is absolute immunity, but only for those core presidential functions. Think veto power, the pardon power, a very limited set of core presidential powers. Then we go into a second area, which is all other official conduct that is not that core presidential conduct. And for that, I think that's probably the biggest surprise here, is that there is what they call a presumptive immunity for all other presidential official conduct that doesn't fall within those official acts, those core official presidential functions. And then, of course, you have a position that was actually conceded by Trump's counsel, which is for purely private conduct. Yeah. There is no immunity at all. So this is definitely one of those cases that once you read the first few lines and you see absolute immunity, you might think that, oh, Trump is completely in the clear. But that is not the case with this opinion. And in fact, even the holding as to absolute immunity for core presidential functions was something the government itself appeared to concede at oral argument.
Catherine Christian is an NBC News legal analyst, former assistant DA at the Manhattan DA's office. It would seem that this immunity case really did come down to what the president did in his official capacity after the election and what he did in a private capacity, shall we say, after the election. Was that essentially the thesis here?
Yeah, and looking at the glass as being half full, the court does say no immunity for unofficial acts. So is allegedly conspiring with private actors, private attorneys to come up with a false elector scheme, is that an official act? I doubt it. But there will be, again, we haven't gone through the whole hearing, but if this will go back to the district court, and if there's a hearing, that will be fleshed out. Will there be a trial before Election Day? I doubt it. 99% chance there will not be a trial. There might be this hearing to determine what were official acts, versus what were unofficial acts, which the court clearly says there is no immunity for unofficial acts.
And Laura, not to disturb you while you continue to go through the nuance here and try to parse it, but to that point, the nuance.
Yeah.
Let's talk about the nuance here, because you've been predicting from the beginning that this would be a nuanced decision.
Because they're worried about not just Trump's case, not just the former president's case, but all cases of presidents going forward in the future, right? And so they kept bringing up the situation of the former President Obama and him ordering drone strikes on American citizens abroad. And the conservatives kept pressing. Are you saying, that that would mean that you could prosecute Obama for having done something like that, ordering a drone strike? So clearly part of his duties as commander-in-chief, right? And I think that that's sort of like the thing that they were wrestling with is how do they make a rule that wouldn't just apply to the Trump case, but would apply to all cases going forward? And they seem to think that they have crafted that order. But of course, as it relates just functionally, as it relates to Mr. Trump, this is an enormous win for him because they've at least drawn some battle lines and said, at least on some things, again, his interactions with his attorney general, that kind of thing is immune.
The district court, this gets kicked back down.
Yeah.
That court will now use the guidance from the Supreme Court to sort of guide its decision.
And the ball is going to be in her court in a way that she hasn't seen this case for the better part of 7 months. Remember, everything has been on ice while the court was taking this up. And the special counsel, Jack Smith, had asked for the Supreme Court to weigh in on this so much earlier so that there would be a chance to get all of this done. He wanted this case done back in March. But of course, once the court took it up, none of the lower courts had jurisdiction. And so it's going to take a while, obviously, for it now to go back down to Chutkan. She's going to have to bring everybody in. They're going to get a chance to make their arguments. And then even at that point, say, she comes up with a rule on what remains of this indictment, right? And even if it's a little bit, if the former president doesn't like that ruling, he might then try to appeal that. I'm not saying he would win that. I'm not even saying the court would take it up. But he might still try to, again, keep the delays going.
Delay being the strategy. All right, stand by. I know you guys are still reading and sifting through. Our senior Washington correspondent, Hallie Jackson, joins me now once again. So, Hallie, here's the thing. President Biden has made central to his campaign the January 6th insurrection. This idea that re-electing Donald Trump would pose perhaps an existential threat to democracy itself. What does this decision, if anything, do to that argument?
It's a great question, Craig, and I'm going to get to it, but I want to get you a little bit of developing news coming into us in literally the last 30 seconds as you were tossing to me here. We are hearing now for the first time from the former president himself on his Truth Social platform. I'm going to read you his full post. It is short. It appears to be a reaction, obviously, to this decision that is out today. He says, "Big win for our Constitution and democracy. Proud to be an American." That's it. Those two sentences. Obviously, this question of whether it is, in fact, a big win for him is one that we are continuing to sift through. It is clearly at least a partial victory simply based on, as it sounds like, the timing of this issue here. And what's interesting here is what the former president is talking about gets at what we're seeing in this decision itself, the back and forth from some of the justices. For example, the liberals who dissented here, one of them, Justice Sotomayor, says that this decision makes a mockery of the principle foundational to our Constitution and our system of government, that no man is above the law. And you are seeing in some of the liberal dissent this suggestion that the majority gave Donald Trump everything he wanted here. Now, obviously, the Chief Justice is pushing back on that, saying that that is not the case, that the assertion that the former president's team made went far beyond what the court ended up giving him. But the bottom line is this: the former president is interpreting this as a victory. As for your question on how this impacts the race and the central argument that the president has been making, President Biden against former President Trump, you're exactly correct that this is part and parcel of the character case, of the fitness case that the Biden team has been making here. You have heard some real criticism from top Democrats about the fact that they believe the Supreme Court took this case up, took as long as it did to get through it, waited until the very last day to come out and put this decision forward when there has been a sense of urgency, they believe, on this. And you have seen this consistently ever since, March, when this first came up here, this frustration with the way that the court has decided here. You're seeing it in some of the liberal dissent. You're seeing it from those previous conversations and those previous statements from Democrats, fits into where the Biden camp has been on this all along. They have, remember, January 6th, they have tried to press this case. The topic of January 6th was one of just a few ads that the Biden camp put forward during that obviously highly watched debate on Thursday night, trying to make the case that because of what Donald Trump did in and around the 2020 election in and around the insurrection on the Capitol makes him disqualified to serve in office. The former president has downplayed this. In that same debate, he essentially talked about the world being respected on January 6th. He has defended some of the people who were arrested for going into the Capitol that day, Craig. I can tell you this. This decision means that argument, this discussion of January 6th, it goes nowhere in this political campaign moving forward. Keeping in mind, of course, that voters have consistently said it is not necessarily what happened around the election fraud lies that is motivating their vote. It is much more those kitchen table issues like the economy, inflation, and immigration, Craig.
Back here in the studio, again, we should note the speed with which our legal team is processing and distilling this information. Quite remarkable from a non-legal guy. How much have we been able to glean from the decision so far, where this immunity, where it ends, the scope and limit of the immunity? Have we been able to glean anything about that?
Yes, we can take away broad principles, and you really could divide these into three major categories. And of course, my colleagues will tell me if I'm missing the point on this one. But really, you can say there is core presidential conduct for which there is absolute immunity. And then you have a circle which includes everything else that isn't that core presidential conduct, for which there is what's called presumptive immunity. Let's go back to that core presidential immunity, because there's a lot of really interesting factual determinations in this opinion, even though so much is going back down to the court on remand for determination. Here's an example. You may recall that in the indictment, there's an allegation that Trump met with members of the DOJ in order to allegedly get them to turn or investigate the election to benefit Trump. And he may have allegedly threatened to replace the attorney general with somebody else who would do his bidding. Now, that is a great example because the court says, look, you cannot look to his motive. As long as he is communicating with members of the DOJ, that is the president's core executive function, and he is immune for that conduct. And folks who may remember those allegations in the indictment, I mean, the circumstances, at least reportedly and as alleged, didn't seem to be investigating an election for the benefit of the election. They appeared to be for the benefit of Trump. And yet the court says that's the kind of thing that because it falls within the executive's core power, there is absolute immunity. Then they go through other factual determinations. And of course, you asked about the last area, and that would be purely private, not official conduct. And there is no immunity whatsoever for that. But in sending this case back down, they are sending it back down with some instructions and taking away some of the work of the lower court. And one great example of that is right here in the syllabus, that the DOJ communications, that meeting, that's the kind of thing that is core presidential conduct and therefore absolutely immune, even though the circumstances really didn't sound so good for the then President Trump.
All right, David, stand by. I want to bring in NBC News legal analyst Melissa Murray. Melissa previously served as a law clerk to Sonia Sotomayor. And do stand by for me a second, Melissa, because your former boss, writing and warning in her dissent in part, when the president uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for pardon, immune, 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 immune. Again, those words written by Justice Sonia Sotomayor. What do you make so far of what you've been able to glean from the decision, Melissa?
So I've done a quick pass through the decision, Craig. I don't know that this is entirely neutral. I think everyone is correct that the court has decided here that official actions may be entitled to a presumption of immunity and unofficial actions are not. But this court actually goes a long way to delineate how certain aspects of the indictment against Donald Trump indicate official conduct for which he would be presumptively immune. So, for example, one of the things that the opinion specifically discusses are those conversations that Donald Trump allegedly had with Mike Pence to persuade him to hold up the Electoral College. The court here says that anytime the president and vice president discuss their official responsibilities, they are engaging in official conduct, and therefore those conversations, which apparently, according to Jack Smith, did not have anything to do with official duties, they are nonetheless part of the president's official duties because they occur with someone who is part of his milieu as president. And it is up to the government to rebut that presumption of immunity. So while this is going to go back to Judge Chutkan, and I think that it is exactly right that this will certainly delay the start of this trial, and we likely will not get a trial here, I think it is much more dramatic a sea change than some are allowing. This is essentially saying that anytime the president does something in the scope of the office, maybe even in we assume that it is presumptively official. And Justice Sotomayor is right. That is a huge sea change from what we have had in the past. And I think it is entirely inconsistent with the constitutional principle that the president is not a king.
Stand by for me, Melissa, as well, for folks who are watching right now, the right side of your screen. That was the scene that is playing out outside the courthouse there in Washington, D.C. right now. As you can see, a handful of protesters have gathered to protest this 6-3 decision from the Supreme Court that former President Trump is, in fact, immune for some official acts as president, not immune for unofficial acts. Let's bring in Jennifer Mascott. Jennifer is an associate law professor at Catholic University. She also previously served as a law clerk for Justice Clarence Thomas, and before that, she was a law clerk for Brett Kavanaugh before he sat on the High Court. Jennifer, thank you so much for your time as well. What do you make of the decision so far as you've come to understand it, again, as we are in the process of trying to parse through the various nuances?
Well, thanks so much, Craig. I think the court's decision today reflects the extraordinary and unprecedented nature of this prosecution. Here we have a presidential administration that's overseeing and supervising the criminal prosecution of the president's current political rival. And I think the justices, in writing the decision today and in how they defined official act, are showing that they're acutely aware that this decision is going to have impact on the scope and role of the presidency, perhaps for decades to come. And so how will this play out in the lower court? Well, as Danny and Melissa and others have been saying, acts that are within the president's core functions, and that can include getting advice from his advisors, but also things like the pardon power, appointing or nominating officials, but a relatively narrow subset of duties. Those he's going to have absolute immunity. So those are off the table for criminal prosecution. But there's this much bigger well of activity, official acts, which I see the court as defining as anything that the president might be doing while he's in office, where it could, unless it's clear, manifestly and palpably clear that it's a private act, there's a presumptive immunity. And what that does is it shifts the burden of proof actually to the government on remand in the district court to have to show that by bringing that prosecution for that official act, there won't be any burden at all on the role of the presidency. And so I think, as folks are pointing out, it will make the indictment and the prosecution below much more fact intensive. But the court has, I think, a measured decision here today, but also one that reflects the historic nature of the issues that were before it.
All right.